Good morning, members. Stuart is my name, and today we're going to look at testate succession. What is testate succession? Testate succession, as we previously looked at in testate succession the previous week, today we're looking at testate succession, and this is where one dies leaving a valid will or valid testamentary disposition. So, in this video recording, we're going to look at the issue of what it is, requirements, domiciles, and we shall find the others in the next video recording. So, as I've said, this is where one dies leaving a valid testamentary disposition of will. But a question is, what is a will? A will has been defined by different scholars. It has been defined in different cases over time, and we are going to look at four cases while defining what a will is. And the first case shall be a Ugandan case, that is the case of Egi, that is Administrator General of Uganda versus Teddy Bukira. And in that they said that a will, this is where one leaves a written document stating all the property he or she owns and the way it shall be distributed upon his death. Meaning that the case of Administrator General versus Teddy Bukira only caters for unprivileged wills that require an element of writing. However, in law, basically of wills, not all wills will be written. Some are not written, like the privileged wills, as we shall later on see. So that is how Teddy Bukera defines a will. However, as I've said, very many cases have come in to define what a will is. There is the case of Smith versus Smith, and in Smith versus Smith, it was said that this is where one leaves a will intending or showing all his property and it shall be and how it shall be distributed upon his death or her death. So this one did not cater that whether a will shall be written or it shall not be written, and that is the Smith versus Smith. However, the most others define it in Goodburn versus Lamage, but the most conclusive definition in defining a will was stated in the case of Rebaga. So for it says this is where one leaves a will, whether written or unwritten. That will comprises of all his or her estate and the way it shall be distributed upon his or her demise. However, it is ambulatory and it can even be terminated or destroyed upon or in presence or in his presence or in his lifetime. So that is the Rebaga case, and it's from the Rebaga case that we get all the characteristics of a will, like it is ambulatory, like it must be written, such other things as we shall later see. So that is the conclusive definition of a will. But after we've defined what a will is, we are dealing with the testate succession. We must know how does domicile apply in testate succession. With the issue of domicile, it is provided for under section 4 of the Succession Act, and section 4A, it says that the Ugandan courts shall only have jurisdiction in succession matters where one left where one was domiciled in any other country other than Uganda, but it shall only deal with immovable property. And with immovable property, borrowing a leaf from our land law, this is property that cannot be carried or transferred from one place to another. And with immovable properties, they include land, they include these buildings, among others, you get. So that is immovable property. So our court only has jurisdiction even though you are domiciled in England, but so long as it is an immovable property like land. And this was seen or re-echoed or re-emphasized in the case of Florence Sally versus chama karania, where in this case the woman wanted to administer the estate of the deceased who had been domiciled in Belgium, but the court said that no, this court only has jurisdiction in succession matters to hear where one died while being domiciled in another country, but we shall only deal with immovable property. So section 4B of the Succession Act, for it deals with where one left property, but okay, where one died not domiciled in our country, but it shall any other law, okay, any other country in which this person was domiciled, that law will apply on movable properties. Movable property, you know, this is property that can be carried from one place to another. So with that, the other laws of the other country shall apply. That is on movable property. So there is section 4 subsection 3 OC for it deals with succession in intestate succession, which I think we ably discussed in our previous discussion. But with this, it says that where one died intestate, he will be presumed to have been domiciled in Uganda, where he had spent 2 years, continuous years, as a resident in Uganda, or where his children or spouse are in Uganda, have been residents in Uganda. So that is the way it applies on intestate succession. So after that, we have to know what is the validity, or what makes a will valid. With what makes a will valid, basically there are 2 categories or 2 elements that make it valid. There is the issue of formalities. It must pass the formalities, as we're going to see later, and it must also pass the issue of capacity. The issue or the element of formalities, it is provided for under section 50 of the Succession Act, and the issue of capacity, it is provided for under section 36 of the Succession Act. In this, we're going to look at the issue of formalities, and with formalities, as I've said, these are provided for under section 50 of the Succession Act, and the major, and with it also it comprises 2, and that is the element of writing and the element of execution. And in this, we are going to exhaustively look at the element of writing. The element of writing is one of the formalities of a valid will, and with the issue of writing, the will must be written. Not all wills must be written. It is only the unprivileged wills that must be written. So we are going to continue in the next video recording, because this one is becoming long.